The next panel and the next topic for conversation is somewhat glibly called "There's an App for That: Participatory Justice in the Digital Age." And we will, I think, to some extent talk about apps, but we'll also talk more. I think the way I think about this panel, and you guys may go in a completely different direction, who knows, it is about how citizens are enabled to participate in the criminal justice system through technology. And to moderate that panel, we have the other of our inaugural class of Quattrone Center Research Fellows, Megan Stevenson. In keeping with the interdisciplinary approach of the center, Megan is actually an economist and not a lawyer, and it's been really fascinating and fabulous, the experiment of having Megan and Sandy together, their different disciplines, and the way that it's blended together to create novel scholarship has been really exciting to watch. Megan's expertise and research has focused on peer effects in juvenile incarceration facilities, non-cognitive factors in crime, pretrial detention and its impact on case outcomes, and the structure of public defenders' offices. She has a bachelor's in interdisciplinary studies with the highest distinction from Berkeley and received her master's and her PhD in economics as well from Berkeley. We were thrilled to be able to lure her away from the land where people live naked in trees to come spend time here in Philadelphia. Fewer trees, but more clothes. Take it away.
So the title started out with the phrase, "There's an app for that." We've since stricken that phrase from the title of this panel because we actually only have one app person. As the evolution of this panel developed, we started noticing that there are all sorts of other interesting things going on, so it's a little broader. So most of the panels that you will hear over this weekend talk about ways that criminal justice professionals are using technology and the implications of these uses. This panel is a little different. In this panel, we're talking about ways that ordinary citizens use technology and how that affects how our criminal justice system operates. The internet age has brought with it a vastly expanded capacity to participate. Journalism is now as much the terrain of amateurs with a phone camera and a blog as it is the terrain of venerable institutions like the New York Times and the Washington Post. The most commonly used reference source in the world, Wikipedia, is generated and maintained entirely by a vast network of volunteers. This current primary election cycle has shown us that the traditional power brokers of elections, deep-pocketed donors in the party establishment, carry less power than we once thought. In their place stands the power of the Twitter sphere, just shared over social media, online networks, and grassroots organizers. The internet age has given people the capacity to be involved with things in a way that wasn't possible before. Institutions have been changing and will continue to change, and the criminal justice system is no exception. One of the more visible calls to change recently has been spawned by the myriad of bystanders armed with phone cameras recording police activity. We've been engaged in a national conversation about policing that was triggered, at least in part, by bystander videos in the deaths of Eric Garner, Walter Scott, and others. Important topics such as implicit bias, accountability, de-escalation training, and community relations are being discussed by police chiefs around the country. Also being brought up is the question of whether the ever-present possibility of recording and viral videos are keeping police from being as aggressive as they used to and potentially resulting in crime spikes. In 2015, the ACLU launched a new app called Mobile Justice in 18 different states. Bystanders who are concerned with something they see on the streets can record a video with this app, and it will upload immediately and automatically to databases maintained by the ACLU. With us today, we have the designer behind this app, a man named Jason Van Anden. Jason has a wide range of interests and expertise, from video game design to robotics, art, music, and of course, social justice design app design. His apps have been downloaded almost 500,000 times, and his work has been featured in Forbes, Wired, CNN, Huffington Post, and many more. I'm very excited to welcome here to this panel to talk more about his work. Another shift we have seen in recent years is the increased use of social media postings as a way to identify those at risk of committing crime, from gang violence to ISIS-inspired attackers. Social media is now one of the main ways that people connect with one another, share ideas, and define their identities. The world of big data brings with it a myriad of possibilities, as well as a myriad of privacy concerns. Navigating how to take advantage of these possibilities to reduce harm without undermining civil liberties is an ongoing dialogue. I'm very excited to introduce you to Desmond Patton, a professor of social work at Columbia University, who has been doing extensive research on how gang-involved youth conceptualize threats on social media, the extent to which social media shapes and facilitates youth and gang violence, and how social media can be used to intervene in youth and gang violence. His work has also been widely covered by news organizations such as the Chicago Tribune, NPR, and Fox. Conversations I've had with him over the last week have been truly fascinating, and I'm glad that you will all also have the opportunity to hear about his work. The final speaker on the panel is Raj Jayadev, one of the founders of Silicon Valley Debug. Silicon Valley Debug is a media, community organizing, and entrepreneurial collective based out of San Jose, California. Raj started a methodology called Participatory Defense, a community organizing model for people facing charges, their families, and their communities to impact the outcome of cases and transform the landscape of power in the court system. Through the Albert Covarrubias Justice Project, he organizes community meetings where the loved ones of people on trial gather to educate each other on the criminal justice process and to search out ways where they can effectively intervene in their loved one's behalf. Despite their name, Silicon Valley Debug is not a high-tech organization. Their use of technology is similar to any of ours. They Google legal questions, organize meetings via email and text, use phone cameras to take videos and photos of their loved ones that they hope will show a softer and warmer side of the defendant in court. However, the core of their model is in-person group meetings, and as such could conceivably have occurred during any era. Yet I'd argue that they are distinctly a product of the 21st century, an era in which people expect to be able to participate and feel empowered to take action. Raj and Silicon Valley Debug has received numerous awards and honors. Their work has been recognized by Congress members of the United States and Assembly members of California. Their participatory defense movement, founded in San Jose, has now spread to cities around the country. I'm very happy that Raj is able to join us in this panel today. So please welcome Jason Van Anden, Desmond Patton, and Raj Jayadev.
Hello. Hi, my name is Jason Van Anden. I'm the developer of a variety of police or social justice apps, and I'm going to basically walk you through I'm going to introduce you to some of the apps that I've created. We're going to do a little demo, and then we're going to follow up with a little bit of talk to you a little bit about the intake process, like what goes on behind the scenes. So let me start off with how I ended up here. I've been developing technology for a very long time. In 2011, when Occupy Wall Street was occurring, I wasn't able to participate in that. We had an infant at home and it was too complicated to try to participate, but I had friends who were. One of those friends was almost arrested, and there was a big protest happening shortly after that. And I ended up writing an app called I'm Getting Arrested, which is basically an app that allows people it was basically the first panic button mobile app. It's something that has become widespread at this point, but it was an app where you could preload a message that you'd want to send to either loved ones or lawyer, whomever, and easily trigger it on your mobile phone in the event that you were arrested. The app was an instant viral success. Like, it went everywhere. I basically wrote the app in a couple of evenings, released it for a big protest on the Saturday after the Wednesday when our friend was almost arrested, and like I say, it became a bit of a symbol of Occupy Wall Street. It became the tech associated with the movement. We'll give you a little demo. Or I'll let Rachel Maddow do the demo.
being arrested.
Should the cops move in on you with zip ties in hand, all you have to do is hit one big, or can I show that there? One big, hard to miss, red and white button, and everybody on your list gets a text that you have been arrested. Can I show how it works? You do that, you click on the button, hold it down, and the nice thing, it gives you the message, be polite.
It's just one button click and instantly the protester's contact list has been informed that he or she is getting arrested. I'm Getting Arrested is right now an Android-only app.
Okay, so the app had an enormous reach. It's currently available in 16 different languages. It's still used around the world by demonstrators. It was, it was pretty cool to basically participate in this way. And shortly after that, I'm losing the. Okay, so, so after I'm Getting Arrested success, the New York Civil Liberties Union got in touch with me shortly thereafter and asked if we could create a version of I'm Getting Arrested that addressed stop and frisk in New York City. At the time, I happen to live in Flatbush, Brooklyn. I would see a lot of stop and frisk. Clearly, I'm immune to it because they were racially profiled, and I'm like, so when they approached me, I was like, great, let's do something. The original idea was to take the same concept as the panic button app and apply it for people who are about to get stopped and frisked. The problem, of course, is that people who are getting approached by the police for stop and frisk presumably are being searched for weapons. And so somebody reaching into their pocket to suddenly trigger an app when the police are approaching them to check for weapons was not a good idea. So in discussing Plan B, we came up with the first video bystander app, which we call Stop and Frisk Watch. Stop and Frisk Watch was released in March of 2012, and it was part of a campaign that NYCLU put together as like a full frontal assault on the policy. There was a march from Harlem to Mayor Bloomberg's townhouse, and we released the app. The next day, the NYCLU basically went to ask the Attorney General to investigate the New York City Police Department, and the following Saturday, they had this march. What was amazing was that the impact of these, the impact was like immediate and amazing, and the stop and frisk incidents dropped incredibly quickly after the release of the app and the campaign. What's interesting is that there was a lot of concern that by dropping the number of stop and frisks that crime would go up. In fact, it didn't. It ended up going down. What was particularly interesting about the release of the app is that maybe the biggest impact of Stop and Frisk Watch was that it educated people and let them know that they were entitled to record the police. And so, it was interesting. The police at a certain point were, if somebody pulled out their phone to record, they'd be like, "What are you using the Stop and Frisk Watch app?" Right. So the whole idea of this app being available changed people's behavior, both the police and the public, in terms of entitling the public to be a witness of what was happening around them. I'm going to do another demo just to give you the features of the app in case you're not aware. Hopefully this will go more smoothly.
Walking down the street isn't a crime. Protesting peacefully isn't a crime. And certainly hanging out with your friends on the sidewalk isn't a crime. So if you or someone around you becomes a police suspect for doing any of those things, you've got the Mobile Justice app. Mobile Justice makes it easy to record and report interactions with the police. The app has 3 main functions: record, witness, and report. Tap record to film an incident. Stop recording by tapping the camera icon, and your video will automatically be sent to the ACLU. The test button lets you see if your camera is working without actually sending a video to the ACLU. Once a recording is stopped, the report screen appears. Include as many details as you can, like names, location, and what happened. Click Submit at the end of the report. You can skip the survey by tapping Cancel, but the extra information helps the ACLU learn more about your video. Witness shows mobile justice users where a police stop is taking place. To use this feature, tap My Settings and turn on Broadcast My Location. Then tap the Witness button to activate. The green light means it's on. Once activated, if someone is using mobile justice in your area, you'll get a message with the location of the police stop. Report is the third function. It's a direct link to the incident report so you can report an interaction with the police without recording a video. Just press the Submit button and the form will be sent to your local ACLU. All recordings and reports are sent anonymously, but you do have the option to include your name, number, and email in My Settings in case your local ACLU office has any follow-up questions. Don't let someone violate your rights because you weren't informed. Go to Your Rights and find out what to do when you're stopped on the street, in your car, or while using this app to film police officers doing their job. You have rights. Know what they are. Know how to protect them. For you and...
Okay, so that was the demo. So Stop and Frisk Watch was essentially version 1 of what became Mobile Justice in 2015. Or 2014. Actually, what happened was interesting. So we released Stop and Frisk Watch in 2012, 8 months before Michael Brown was shot in Ferguson. The Missouri ACLU got in touch and asked if we could create an app for Missouri. We actually, everything was in place. We actually started developing 2 weeks before that event occurred. We were in a position to release that app quickly, so we ended up releasing that app. It was used in the protests in Missouri. It's a way to document police activity and what was going on during that. So just to go over the features again, which is kind of interesting, is that there's basically, there's 5 kind of main features and then like an extra bonus feature in the app currently. We've got the record function, we've got the report function, we've got the know your rights function. The know your rights is actually incredibly important in this context because what's happened is that you've had close to 500,000 people install the app. And in some ways, they all have this pamphlet understanding what their rights are in terms of reporting the police, what to do and whatnot for their different jurisdictions, different states. The witness mode was written originally, was created actually for situations that were maybe more urban, where not only were you enabled to record the police, but that you should be aware that you're allowed to go witness these events in person. So the idea of witness mode was that as an event is actually occurring, as somebody's recording a video within your vicinity, you can receive alerts with a link that would allow you to go and see the event yourself. Okay, so the app's actually evolved quite a bit, and as intake has become more important, given that there's been tens of thousands of videos that have come in, we've developed a back-end for the system that allows for intake. And it's actually gotten a lot more sophisticated last year. Initially, the intake was simply like a way of having the content. What's actually happened is that it's evolved to a state where you can actually reverse query based on incidents that have occurred. So in other words, if an event occurred where the police shot somebody in, let's say, Venice Beach, California, you could actually query for any videos that may have been recorded within 5 miles of that incident and immediately see if there's anything potentially actionable in terms of what's intake. All right, so that was around the right amount of time, and I'll jump back and take questions now. Thanks very much.
Hi, good afternoon. Before we get started, I just want to orient you to kind of who I am and some of the work that I do. So in 2010, I was doing research in Chicago, and I was interested in the ways in which young people navigate community violence and how their navigation strategies impact their ability to stay engaged in school. So I was following a group of African-American young men that were in a local charter school in the west side of Chicago. And one of the things I became acutely aware of is that I was focused a lot on their ability to navigate violence in the neighborhood. But many of these young men were also navigating a different context, social media. And in particular, they were telling me extensive stories about what they saw online, who they talked to, who they interacted with, and some of the fallouts of communication that went awry. And so I became really interested in how their experiences online overlap with their experiences offline. So I'm a youth violence researcher that is a social worker, and I study social media in particular. And then I graduated, went off to the University of Michigan where I started my first position, and during that time in 2012, there was another big situation that was unfolding in Chicago where there were two very well-known rappers that were having an argument or a beef on Twitter. And this particular situation really escalated over time, and one of the lesser-known rappers actually tweeted out his location on Twitter and essentially said, "If you're bad, meet me here." And lo and behold, within 3 hours, that individual was killed in that very location where he tweeted. And then the more well-known rapper came back to Twitter and made fun of him, essentially, and kind of made fun of his death. And so I really wanted to learn more about these types of interactions. How does communication online lead to firearm violence? And so this is my line of work that I'm pursuing. So what we know is that social media communication has radically changed the way we all interact with one another. And in particular, it has really reconfigured how young people engage one another and how they communicate. Young people are sharing very personal details and information about themselves online. They're also forming communities and gathering their news from their social media connections. And they're also curating their identity. They're using words and emojis and videos to kind of develop and represent themselves online. However, this high level of connectivity also has raised concerns about cyberbullying and online harassment, which represents a growing public health issue. However, our current discussions around cyberbullying and online harassment may not accurately reflect the lived experiences of young people of color who live in violent neighborhood contexts, who are oftentimes experiencing everyday violence and trauma that uniquely impact how they communicate online. So in my work, I focus on youth of color who may post messages online from street corners, schools, apartments, and other neighborhood spaces that are embedded in the local ecology of violence. On the one hand, youth can use social media to cope with neighborhood stress and trauma. So that means they can easily build relationships with friends and access a community of online peers who in some instances may just live down the block. And so they can share their stories, they can grieve the loss of a loved one, they can grieve the loss of a peer that has gone to prison. However, conversely, tough talk on social media can also fuel conflict between individuals and peers and create greater tensions between youth and police that incites violence in communities. More specifically, some youth are using social media to brag about violence or gang affiliation, post fight videos, and insult and threaten others. A phenomenon I've termed internet banging or cyber banging. But to better explicate what internet banging is, I'm going to tell you a story. I'm a qualitative person, so I always have to come with a story. I want to tell you about Jakira Barnes. I first learned of Jakira from some of my on-the-ground fieldwork in Chicago and through extensive media coverage surrounding her death. I was intrigued by her young age, her high-profile status as a female gang assassin, and her Twitter popularity. An article in The Guardian, which circulated in Chicago as a part of her renown, termed her the teen queen of Chicago's gangland. So Jakira, based on her Twitter profile, had a tough guys, and her peers perceived her to be a willing and able fighter, and rumor had it she killed or shot up to 20 individuals by the time she was 17 years old. This is by 2014. However, Jakira's mother thought that putting on a tough front and being the biggest and baddest is actually a part of social life in Chicago. Being a teen that is learning how to cope with everyday experiences with violence means garnering respect and posturing in ways that allow you to receive that respect. So Jakira grew up on the south side of Chicago in a neighborhood that had been deeply impacted by poverty and the effects of violence and trauma for decades. And Jakira routinely experienced violence in her everyday life. Her father was shot and killed before her first birthday. 2 of her very close friends died during her formative years. And at the age of 14, she was introduced to a group of boys in her neighborhood who belonged to a faction of the gangster disciples on the south side. However, what really drew me to her was stories around the death of her friend. So on March 29, 2014, Jakira's close friend was shot and killed by a Chicago police officer. And this particular death really shook Jakira to her core. Now remember I was telling you that she was someone that had up to 20 bodies associated with her. But as she grieved the loss of her loved one, I learned about a very different person. I actually realized that I was asking the wrong research question. And so I initially was interested in, well, can I identify forms of communication in her Twitter profile that are emblematic of aggression and violence that may lead to retaliation? And I saw some of that. But I also saw a child. I saw someone that was grieving. I saw someone that experienced immense amount of trauma. I saw someone that was seeking attention and seeking love. And this narrative that she trusted to us through her Twitter account was not being told. And so all we were able to read and therefore encode was a violent young woman that was going around Chicago killing a person, and not a narrative that humanized her as a person. And so I wanted to dig deeper and be able to, as accurately as possible, be able to reflect on her story. So less than a month later after her friend was killed, a tweet from Jakira's account gave the address, street apartment frequented by members of Jakira's gang, and was accompanied by a picture of Jakira and her friends posing on the steps of that home in the Woodline neighborhood of Chicago. Later that day, Jakira was killed just blocks from that address. At the time of her death, she amassed over 2,500 tweets or Twitter followers, which placed her among the 98th percentile of all Twitter users. She posted over 27,000 tweets from the time she created her account in 2011 until her death in 2014. And so this was someone who was very engaged in Twitter and had a lot to say. So in this particular study, I used inductive textual analysis to examine a relatively small subset of Twitter data, only about 800 tweets. I decided to examine a small data set because urban gang-involved youth curate a unique and complex and multifaceted communication style within and between social networks that warrants careful and attentive coding by hand. The language represented in these tweets exhibits significant social linguistic variation from standard English, the use of which represents a key part in how youth in urban settings curate their identity. Such communication not only uses unusual words, phrases, and grammatical constructions, but also references neighborhood identities, rival gangs, and local rap music. So, given the linguistic variation by city, regions, and gang factions, these tweets would be difficult to decipher solely using automated scripts, network analysis tools, or crowdsourcing. So, in an effort to increase our chances of correctly deciphering the language, context, and culture embedded in the tweets, I assembled a team of youth from Chicago who were from the same neighborhood or from surrounding neighborhoods that Jakira was from, and also researchers that had experience doing urban-based gang violence research, and also data scientists that had experience with natural language processing tools and applying those tools to cyberbullying work. And so prior to Jakira's death, her tweets from her account referenced feelings of isolation in a violent environment where death in early age was expected and discussed colloquially amongst her peers. And so my analysis of her tweets found examples of aggression in Jakira's Twitter network that were closely aligned to Elijah Anderson's work on Code of the Street, which resembles 3 mechanisms of gang behavior that have been identified by Andrew Papachristos. I think we've alluded to his work around hotspots in Chicago. And so we looked for these mechanisms within Jakira's tweets. And so we categorized her tweets based on those 3 mechanisms of intergroup conflict, reciprocity, and status seeking. We also identified emergent themes that highlight the convergence of geographic and digital space that Jakira's network represented, including examples of group tweeting, where a set of users' names are used to make a comment about another group, or spatial referencing, which I referenced a little bit earlier. And so in this work, I proposed that the group processes and gang violence mechanisms that Papachristos identified are not fixed or categorical, but rather fluid, reflecting the dynamic interactions of networks, local ecology, and social-emotional behavioral characteristics embedded in urban street life. And so just a few examples of how Jakira communicated. I wish I would have put them on the screen here. But one tweet that I thought was really interesting was one that said, "Just bought a crate of guns. I'm on my way through Land Ron. Shoot who's ever next to you." And I mean that. And so in my own assessment, I initially thought that this was a very aggressive and violent tweet and it's something that we should pay attention to. However, when I asked youth to interpret this tweet, they had an interesting kind of take on what was happening. First, they were able to recognize that the use of Lam Ron was actually an indicator of gang territory. And so what they told me is that the use of Lam Ron was actually backwards for the street on the south side of Chicago named Normal. And this street is a hotspot for the Black Disciples, which is a rival gang territory in Chicago. And so essentially through this tweet and through this coded language, a threat was being communicated. But had you not had the neighborhood sensibilities and understandings of what or how phrases are used, you may have missed the clear identification of a threat or where a threat is going to take place. But also, I also identified tweets where Jakira was emoting through her grief and loss. She said things like, "The pain is unbearable," or "No one understands my pain," in the same moment where she was making threats. And so here you see the extent to which grief and loss and violence are converging. And so this theory building is being used to do collaborative work with community-based organizations and to do more big data research. And so I have partnered with Cure Violence, which some of you may be aware of. It used to be a ceasefire in Chicago. They are collecting social media data using Geofeeded, which is one of the third-party organizations we kind of alluded to earlier as well. And so I'll be analyzing their data along with data scientists from Columbia University to see if we can identify clusters of high-stress language in tweets. And so essentially what will happen is, in my part of the work, I have developed an analysis framework that annotates ways in which to look at tweets. And I know you may be thinking, well, how do you do a deep dive on 140 characters? And one of the things we do is that we look at the events or risk factors that help you understand what's happening. We really look at the author of the tweet and we look for things like what's in their handle, what is the context of their profile, where are they from, who are they friends with, are they talking to other gang members, do they have a mixed group of friends online? What about the content of the tweet? Are people gangs references? Are there references of spatial referencing? Are there clues, so looking at the tone of the tweet, looking at how conversations are unfolding, looking at punctuation and capitals and abbreviations and numbers and things like that. And then we look for a break in communication. So we look for the movement from a general conversation between two friends, then to an event or a situation or a sentence or an emoji that then moves that conversation and escalates it into a more aggressive tweet that could potentially lead to firearm violence. And then that work is then used, and I give that annotation to data scientists that then are working to create a suite of algorithms that can then detect patterns in language. Our overall hope and goal is to be able to create systems in which we can give information to social workers and violence prevention workers, social media data in real time, so that when these things are occurring, these patterns of escalation online are occurring, they can then have this information when they're doing their intervention work. And I can talk more about that in the Q&A. Thank you.
Okay, good afternoon, everybody. Unlike Zeke, this microphone's perfectly situated. Yeah, I want to thank everyone for having me out here. Let me grab my phone so I can keep an eye on the topic. Technology. So I'm from San Jose, California, like Megan was saying, and we have been employing a methodology that uses the technology of community organizing to challenge the criminal justice system status quo and ultimately mass incarceration. And sort of like what Jason was talking about earlier, I think it's a reorientation of what is the capacity of people that have been perceived as powerless or bystanders, or not an actual player on the field. Is there a way to empower them with some tool, some weaponry, some device that allows them to enter the game to actually change the outcome? And that's sort of what we've been playing with for about 7 years in San Jose and now sharing with other communities nationally, including this area here in Philadelphia and some neighboring counties. So what this is my table back home at my community organization, Silicon Valley Debug, and what you're actually looking at is you're looking through a glass that Gail is writing on. Gail is writing the names and taking notes of everybody that's in that room. Everybody that's in that room is either facing a charge or has a loved one who's facing a charge. And they decided that they're going to do the very courageous step of rather than simply allowing the criminal justice to do what it's going to do with their loved one and then deal with the consequences after the fact, but to actually engage to try to change the outcome of whether that person is incarcerated or not. This is the courthouse of my hometown, Santa Clara County. And I don't know what it's like at the courthouses here in Philly or where you're from, but that's a line that snakes out the door every morning at 8 o'clock and at every lunch break to start afternoon session. And I can't think of a more anxiety-filled space in my county than waiting to get in line at court, particularly if you're not a lawyer, but also if you're a lawyer. And so what we really wanted to do was reimagine what the capacity was of those who are standing in line. For the most part, what you're looking at is sort of the hallway into prison, which the court mechanism has been a delivery system that has led to over 2 million people currently incarcerated, 1 out of 100 Americans, and taken and destroyed a number of families and communities in the area where I live in. And so what you're seeing is people getting in line, going into a system where they don't know whether they're going to see their kids again, what the outcome will be, if they'll go to prison or jail. When they come out, will they be able to restart their life? And so our fundamental question was, can we equip them with some sort of skills or empowerment that could change their experience once they step through those doors? And so what we started doing, as what Megan was saying, was essentially go to our bread and butter as a community. And what our community certainly know is when we feel that there's an individual that we care about who has had an institution on their neck, the technology we have used has been collective action. It's been this tried and tested methodology that collective action is more powerful than institutions that are trying to harm or injure someone we care about. We see that play out in things like even like ceasefire in Chicago. Every urban city in the country, when there's issues with schools, with transportation, with civic engagement, with police, families and communities get together and exert a collective power to change the policies and also change the outcome of that situation. And we thought, well, should this also apply to the criminal court system? Should it also engage a system that has been insulated from community organizing really since its inception? And what would happen if we did? And so what we started doing was having meetings around that table. And like the picture that you saw earlier, these are folks, there's an area actually in the corner who at that time was facing a life sentence because of the work that the community did, his public defender did. Neri is now a free man, is not wrongfully convicted in one of those horror stories that you read about, you know, having done 20 years and the Innocence Project gets him out. We thought we could stop that from the front end. And so what the principal way we've done this methodology that we're calling participatory defense has been meetings of families that are half support group, half strategic planning meeting. And so what happens is families get together and they get a status update procedurally of where their loved one's case is, identifying things like what the next court date is, what's happened so far, what request does the attorney have to properly defend their loved one. And then they actually create a game plan using the collective intelligence of the room, other families who've walked down that similar road, new people that are saying, I have that same courtroom, I'll go with you. And what they've identified is sort of a new practice that feels very instinctual for a family that says, I wish I could do more, right? And stretch that bandwidth of agency from what the limited scope was originally. So when you think about that line in court, what is a family to do when a loved one gets arrested? What's a church leader to do when one of their congregants comes to them and says, pray for me because my son got arrested and I don't know what to do? The most that people do is hope and pray. They might show up in court. They might try to hold a car wash to raise money to hire a private attorney because the presumption is if you don't have money, you don't get justice in this country. But the reality is, over 90% of people who face a criminal charge will have a public defender. And what that means, sort of the equation of it, is that we have to equip the people who have an actual standing to advocate for someone in court, the public defender, with the tools and resources they need to properly advocate for the people that we love, our family members. And so what if we can make the family an effective, essential extension of the defense team? And what these weekly meetings became was sort of that source. So families were doing things like gathering information that would help fill out or flesh out the situation around the arrest, investigative material that it was hard for an investigator or lawyer to memorialize, ensuring that people that could have been potential witnesses who wouldn't trust anyone that shows up with a card, whether they're from the defense side or the prosecutor's side, was communicating to the defense attorneys and investigators, gathering things like school records, medical records that were sort of far and out of reach of a defense attorney that was under-resourced, had too many cases and only had 15 minutes per case, so how are they going to do all this legwork? Well, the reality was they had someone that was on their team now that was profoundly invested. The family member that was really sitting on a lot of this knowledge and information, that really just wanted a way to communicate it, a way to play a role. And what I was telling you earlier was waiting in line in court. was one of the most anxiety-filled moments. It's also the most isolating, despite the raw numbers of who's actually standing in court. And the court experience altogether, right? Not just for the person detained, but the people who love them as well, who feel completely unsure of how to navigate, unsure to have any sort of impact. They're not caring for the rest of the people in their family because their loved one can't make bail and all they can focus on is that. They need to see how they can get off of work to attend court. They're not thinking about their other child because their other child's in juvenile hall. They want to see how they can have an impact. Well, the other actor that we thought was also isolated once we got to know them was the defense attorney, who felt that the odds were stacked against them to actually get the outcome that they wanted. And the results were mathematically sort of accurate. When you look at, say, our county, which is a well-resourced, we're part of Silicon Valley, we have a 98% plea rate. The national average is over 90%. And I'm not saying that plea agreements are inherently wrong. I'm saying that there are some decisions being made because of the coercive nature of the isolation of the person facing charges and potential resources that have been excised out of the equation. And so what we found is when we brought collective action back to the process, we could actually change outcomes of cases. So tangibly, what the tools of participatory defense manifested into were things like social biography packets, where families would cull together important information that could be targeted and useful for the defense attorney when they were negotiating or in front of a judge for sentencing. Those evolved, like Megan was saying, to videos, so that we could sort of deconstruct the sterility of the court. And when a judge was trying to make a decision, like the risk assessment was talking about, they got to actually go into that person's home, meet their family members, see who their future prospects were by meeting the people who would vouch for them. That was our way of trying to change the way that Dr. Burke was talking about how you make a decision around Darth Vader and Luke Skywalker. Our challenge was, how do we tell the fuller truth about Darth Vader? How do we say that this issue is more complicated than you really understand? And so what we found was tangible impacts on cases. There were charges that were getting dropped, acquittals, charges that started as felonies dropping down to misdemeanors. The public defenders who at first did not know what to do with us started reaching out and said, oh, I realize now this is a resource. Let's see how we can work together. I can send a family your way to the meeting. And we had one ceremony at these meetings. So I told you earlier that people write their names on the board. And so what would happen is people would get to know the names because they'd be a name that another mother, or another brother, or another loved one would write on the board every week. And we get to know their stories, and the community would be attending court all the time with them, or getting case files, or reviewing police reports, doing whatever they can. They got to know the person, but that person was always detained because they couldn't make bail. When a case was resolved, when we reduced the sentence or the charges were dismissed and they came home, that person would come to the weekly meeting. And the one ceremony we'd have is when their name came up, we'd give them an eraser, we call it the eraser of justice, and they'd erase their name. And it seems so trivial, but it's the most ceremonial aspect of anything we've ever done. Because for these other families that are watching this, they're just starting the experience and are thinking, there's no way I can make any change. There's no way I could bring my loved one home. They get to see the process. So some of the examples, just so you know, like this is Carnell with his beautiful daughters. And Carnell came to us after he took a plea, but before he was sentenced. It was a low-level drug charge, a $25 drug charge. But he was facing a 5-year prison sentence because he had priors. And we knew him as a dad. He'd bring his daughters. He was a single father. And so he said, I could do the time, but if I go in, they're going to take my girls. And so we gave him a camera, like Megan was saying, just cell phone cameras, and said, take pictures of what it's like being a dad. So he took pictures of making the girls breakfast and taking them to school and after school programs, tucking them in for dinner, making them breakfast for the next day. And he turned it into his defense attorney used it to change the opinion of the probation officer when they had to do an indicated sentence. And then the judge, who originally indicated a 5-year prison sentence, turn that into a 6-month outpatient drug program so that Carnell could be with his daughters and so that he could tell the rest of his story because he understood Carnell is more than just that case file. He had a full understanding of the collateral consequences of a looming incarceration. So what we did is we came up with our own made-up metric. I know there's a bunch of social scientists and I'm at a university, but as organizers, we need to find a way to get the community involved in a way that they otherwise thought was not within their scope. The notion that, well, if I'm not a lawyer, there's nothing I could do. We wanted to radically change that. Not that we wanted a bunch of pseudo-lawyers, people trying to Monday morning quarterback defense attorneys, just to have a role and to do something. And so what we tell people at the meeting is, look, if you just sit on your hands, your loved one is going to get time served. That's time of them incarcerated. But if you engage, if you participate, if you're a resource for your defense attorney, you can turn time served into time saved. That's them home with you, living the life that they should be living. So Carnell, for example, would represent 5 years of time saved in our organizer math metric. When we totaled the numbers at the end of 2015, we had 2,500 years of time saved from incarceration. That's based on what someone was facing when they first came to us, and then what they ended up receiving after the family engaged. But what we realized that if we needed to transform the consciousness of who was going into that line and the communities that they're from, we had to change the perception also of the public defender and how they're perceived, because there was no story being told about them except negative stories. So we had a time-saved party, and we brought all the families together, and we brought the public defenders who accounted for those numbers, fought for those numbers, and they passed the microphone, and they shared their appreciation. And there's a new understanding of what the potential was of community and defender offices. I'm going to show you one kind of technology thing, just because it said technology on the program, and I don't have an app, and I want to show something. This is a video of, it's bus stop size. This bus stop sign says time served, and it says when families and public defenders work together 18 years. This is Lisa Coulter. She's done 18, but she's facing potential release. Just keep your eye on it while I'm talking. This is hanging in the lobby of the public defender's office. And there's a QR code to a mini documentary. We started making these mini documentaries of time-saved stories. We have one actually from Montgomery County that we made. So when people walk in the office, the darkest moment of their lives, thinking, this public defender, there's nothing I could do, and they see her and they're like, man, that's me. Just alone, incarcerated. And they're thinking, what can I do? And then they shift perspective. People see that? And then time served became time saved. And 18 years became life. And the rest of the sentence pulled in where it said, when families and public defenders work together, loved ones come home. And it was a way that we wanted to show the dynamicism and possibility of change if people engage and don't just take the status quo as is. And that was our way to now change the larger public consciousness. The work has led to policy changes as well, not only just in perceptions of defender offices, not just individual cases. What happens in this new level of engagement is that when people start seeing the court as alterable, as malleable, and where a space of community organizing can leverage tremendous power, because you just drop a little in it, it's never seen it before, it can make changes. So campaigns erupted that otherwise never would have happened. So that's us fighting for changes around bail reform. We ended up winning a campaign that got public defenders in misdemeanor arraignment court because we realized that it was happening in other places. Just talked to Mark, the policy director of the Philadelphia Defender's Office. He's talking about he went to the council recently to propose a budget around making sure the public defender's office was well funded, right? Had this great presentation, had a video even. There's a packed audience of the public. They're there for the soda tax. That was the next item on the council meeting, right? But that should be a community campaign. I would suggest that resourcing defense offices is not a public defender campaign, it's a community campaign, where if we want the weaponry of justice in the courts to be effective, it's our responsibility to equip them. So that consciousness level is changing as people work on cases. I wanted to put Kira Bradford up on the slide because this is her hometown. She was one of the first people that took a chance on us as a defender, along with Margaret over here, to help initiate the participatory defense model in other places. So right now, we have participatory defense models happening in Montgomery County, in Nashville, in Memphis, in Birmingham, starting in Brooklyn, hopefully starting in Philly. And it's about realizing the kind of next stage of Gideon's dream. I'm going to edit there because I have a lot more to say, but I'm excited. So, thank you.
So I have a long list of questions. I'm sure you guys all have some questions too. I'm going to take moderator privilege and dive in with a few of my own, and then we'll quickly turn to audience questions. So Jason, you've talked about the ACLU as an honest broker to sort of mediate between video collected and the public. Can you talk more about what this honest broker, what the role is and how that's important?
Yeah, so, I mean, in some ways, people have always been able to videotape using their phones. Using with mobile justice and stop and frisk watch, the video goes directly to the ACLU, and so there's this idea that the organization that's receiving and safekeeping that video is going to do something responsible, or determine if it's actionable and then do something responsible with it. And so that's this notion of an honest broker. They're also working, each affiliate is its own entity, and each affiliate, works within its own jurisdiction, so they're familiar with the laws that are specific to that area. So again, the idea here is that we know the video came from the app, so there's some qualification on the video coming in, and it's going to an organization that, by virtue of you installing the app, you presumably trust if you're going to use the technology.
So Desmond, I know from conversations with you that you have another line of research that focuses on social media policing. Can you tell us what the police are doing as far as using social media in their investigation or in the cases, and more about your research in this area?
Yeah, absolutely. So this interest in social media policing really kind of spawned from my work with people around how to communicate online. And after having conversations with police in Detroit and in New York, I've learned that social media is used in multiple ways, but in particular, how it affects young people is it's used to determine whether or not someone is going to make a threat. And so they look for examples of posts that may provide some clues around threat. And then also it is can be used as a part of character testimony. So if we're able to monitor and observe individual social media communication, what about that communication gives us more in-depth information about individuals? So for example, if you're in New York City, you're living in one of the NYCHA public housing units, and you are following individuals from your housing unit. You may not be real friends, you may not hang out with them at all, but you all will follow each other on Twitter. You become lumped into a group of people that are then monitored and observed over a period of time. And so in my new project, I'm partnering with a colleague from Rutgers University to better understand how attorneys and the police are using social media as evidence. Is social media a reliable data point? And then we're also interested in to what extent we're doing a national opinion poll to see to what extent people are willing to allow various forms of surveillance. What are the barriers and parameters around how much surveillance is good, or to what extent is it problematic?
And so just to follow up on that briefly, how can you tell from a post whether someone's just trash talking or if it's a viable threat? And related to that, do you feel like there's potential, racial implications and how this is used in policing or disparate impacts on communities of color?
Yeah, absolutely. So I think interpreting threats is a real challenge. I think because we get to the point around, well, what is intent? And I think understanding intent is, I think, impossible because you need to be inside someone's head to really understand the intent of a post. However, I think social media gets us close to, gives us clues. And so when I talk to young people in Chicago around what threats were to them, they were very clear on, first, they read a post based on who was the author of that post. And so, for example, if the post was disseminated by someone that was a known gang member, that had gang affiliations, that was known as in the community as a tough person, then those posts from that individual were taken as true, as real. So if they made a threatening post, then that was a real post to them. If those posts had clues around location, or they were subtweeting individuals that were known gang members, then those posts were more likely to be real. They were also very clear on what wasn't real. They were very quick to interpret some posts as being rap lyrics. And although the rap lyrics may on the face look aggressive or violent, the young people thought that more times than not, those posts were in the moment posts. A young person is on the train, they're riding home, they're in the moment, and that post was really about an everyday kind of experience and an emotional connection to a song. However, if you're not from that space, and this is where we get to kind of the encoding of tweets and whether or not and applying a racialized lens, you may look at the tweet and it looks aggressive or violent based on how you approach the tweet, then you can make an interpretation about an individual when they really were just posting a rap lyric on their way home from basketball practice.
Thank you. If anyone has any questions, feel free to line up. But Raj, so how have, I assume or I'm guessing, and please correct me if I'm wrong, but I assume that defense attorneys have mostly been very supportive of the work that you've done and very enthusiastic about it. How have prosecutors and judges reacted to it? Are they excited? Have they expressed any concerns? How is this rippling out into the community in terms of how they see it?
Yeah, well, I would say this about defense attorneys. Originally, it wasn't met with a lot of hugs. Just because it was an odd new animal in the court process, and there was, I think, some good natural tensions about what's the purpose and why are other families showing up for my client's case, or why does this family want to have a meeting with secure time versus the 2 minutes in the hallway that I'm used to doing. And then once they started seeing the value of it, that it wasn't about, say, critiquing the defense attorney's actions or trying to tell them what to do, then that's when it really turned around. For prosecutors and judges, it's been the same process when you democratize a public space that otherwise has not been, for the most part, in practicality. So judges in particular have been very supportive because, say, the social biography packets or the social biography videos that families and communities are submitting through the attorney, that's not really making a proclamation about innocence or guilt. All it's really saying is, if you're trying to make an informed decision on what to do with this person's fate, you should have as many points of references as possible to make an informed decision. And all we're giving you is another point of reference. So the judges have been really have been responding really positively to the end product. The prosecutors as well, when they've had to make decisions on should this be a life case or should it be a determinate sentence, they have a panel of prosecutors that have to make that decision. And they're in the same position essentially as a judge. So they've been supportive on the end product. In terms of having people in the courtroom that are now watching their actions and making sure that people are treated with dignity and respect, I think it's situational based on the practices of the prosecutor and the judge.
So just as a follow-up to that one, I can imagine at some point when judges start getting really used to seeing these character testimonials and seeing the human side and the family side and seeing the family come out and support defendant, that when that doesn't happen, that might sort of raise red flags for them. And they're like, what's wrong with this person? Is this somebody who's really dangerous and I should really lock them away? When in fact, it's just somebody who's been really unfortunate, whose parents aren't there for them, who's, perhaps they're locked up or dealing with mental illness or drug problems or too busy at work to get away. Do you think there's any, I mean, we're probably far from that place, but do you think about that aspect, the people that aren't able to kind of take advantage of your methodology?
Yeah, in two ways. One is the past trauma or the lack of connectivity is still an important part of the story for those that don't have it, and oftentimes it's just not seen. And so so part of it is just an understanding of the vacuum in the room, and for a judge to be considerate about what that means. From a community organizing perspective on, we want to see that person have alternatives to incarceration or a reduced sentence. What that really means is that person is ripe for what would happen if those assets were now introduced into their lives. Maybe the lack of support led to a particular criminality, but all that means is if you do add some stability or structure or support, maybe that dramatically increases the odds that they're not going to reoffend. And so in some ways it's been about us marshaling different resources to then support someone on the tail end. So that way a judge in that situation can feel that there are reasons that are offsetting their sense of risk so they don't feel pigeonholed into an incarceration.
Thanks. I really enjoyed your comments, each of you individually. I have lots of questions that I'd love to ask you. But the first question, actually, Jason, is I'm interested in the anonymity component of the ACLU video app, and I'm wondering what percentage of the videos that you've received are anonymous, roughly, if you know, and whether any of the anonymous videos have been things that you've tried to use in complaints or litigation, what the impact of that anonymity is on your ability to use them down the line.
So I don't have frontline experience with the intake. I only have, I don't know those numbers exactly. So I can't answer that question in a clear way. I do know that, most videos are not actionable, and the ACLU goes through a lot of videos that are that they, I know they found some, but yeah, most of the videos so far have not been actionable videos. What's happening right now is that some affiliates are training people in communities that are targeted by these policies so that they can get better quality videos. And basically, they're taking, they're going into communities and training people on how to use the app in more effective ways. And the quality of the videos being submitted has improved after they've done these trainings.
Okay, thanks.
Sure.
And can I ask a second question? Thanks. With the social media, I was struck when we had the predictive policing conversation, and the unmarked cars were being rapidly identified, by the kids in the neighborhoods. And I'm wondering if the effectiveness of police in the areas you've looked at sort of infiltrating these social media networks and understanding themselves. Do they know what's going on in these networks? It seems like you're putting a tremendous amount of energy into identifying and deciphering it. I'm sure that law enforcement is trying to do the same thing, and often for many of the same reasons. How successful has that been, and how sort of do they stick out as much as these plainclothes cars that everybody knows who they are?
Yeah, that's a good question. So, many urban cities within their gaming units have a social media component now to their gaming units. And so for several years now, they have been monitoring social media. To what extent they're successful, I have no idea. I think a part of the issue is transparency and really understanding how social media data is used in making decisions. And how social media content is interpreted. And I think, in my anecdotal conversations with police, I think in my experiences, they have made various decisions around social media that is based on their individualized experience with young people in their neighborhoods, and it isn't really grounded in anything else beyond their experience. In some situations, I've learned that police are creating fake profiles to interact with individuals on social media as well, and they create a profile based on what they think is how a black man talks, how a black female talks, which is, in my opinion, highly problematic. I'm interested in perhaps, I'm certainly up for having deeper conversations with police around how to have a more holistic perspective that is informed by how young people think about themselves and how to think about community and how to think about their own social media use without putting an adult perspective on how young people are communicating.
Can I follow up on that real quick? So my brother-in-law doesn't use text messaging. He only uses some app service that's super encrypted and coded so that nobody can ever find out what he's saying. Are the kids that you're interviewing thinking about these privacy concerns? Are they thinking, oh yeah, the police are monitoring this. This is going out there. I'm going to use this new system where nobody can, where I'm invisible, or I'm only visible to the people that I am, willing to broadcast.
That's a great question. I believe we have a significant issue with digital literacy. I think many of the young people that I'm speaking with think that their communication is only within the confines of people that they're following or that they're friends with. They don't have a strong understanding of the impact of the comment, the longevity of the comments, that it can last forever, and that it could be far-reaching. Some of them are aware that the police are monitoring social media content. Again, I think what we oftentimes forget is that young people who grew up in violent contexts are young people. Young people are in a very complex developmental time period where they're making bad decisions all the time. And so there's an abnormal behavior, right? to engage in behaviors that may not make sense to adults. But I think this digital piece should become a part of how we create better relationships with young people generally.
Can I just say real quick on this? Because what we've seen is law enforcement not necessarily trying to do sort of an honest investigation on whether someone's a gang member or not because they want to find the truth. What we've seen is law enforcement identify who they want to build a case on and are trying to find and grasping at anything they possibly can to help tell that story. So they're submitting Facebook posts that show someone wearing a certain color, or a 16-year-old that is putting up a W and saying they're gang related. So in some ways, it's what the end result is. They're not taking maybe the academics kind of view. I think it's more about they have a finish line they're trying to meet, and Facebook posts and Twitter posts are just a way to get them there.
So I really enjoyed the panel. A lot of what we were talking about this morning was looking at different ways in which we're using data and technologies to predict in the policing arena with prosecutors and police. This panel is making us think more about the connection between other actors in the system, defense and community. And I'm wondering if there's other ways in which the connections between what the three of you have spoke about so eloquently could be used in the adversarial process, more in the trial process, and helping how can defenders use not just community organizing, but use it in the sentencing process, but also in the trial process, the motion to suppress process. Have you seen that in your work?
How technology is used?
Yes, yeah, or the gathering of data, the participation of communities, the information that we're getting through technology.
Well, I can tell you one thing that we've done, again, it's not the technology so much, is, so in California we have gang enhancements. I don't know what that happens out here. But you get charged with a crime, the prosecutor says that it's connected to gang activity, they put a gang enhancement on you, then dramatically grows your sentencing exposure. And so what would happen is prosecutors would have a gang expert, and it traditionally would be a retired police officer that did a couple hours of training through some training program. They certify themselves as gang experts, and then when a trial happened, they get on the stand and say, I'm a gang expert, your client's a gang member, this is a crime committed in the act of a gang. The defense bar did not have really inadequate response, besides cross-examining the police gang expert. Well, guess who knew gang experts? The community. We had folks that were absolutely validated by the prison system and then had turned their lives around, as the common story is, and were doing gang prevention for the city. So we were able to offer up our own experts from the community. We did the same thing with graffiti and other sort of crimes that you need to have a real proximity to the issue to understand. And they started winning cases on that way. Because of their knowledge of like the stuff Desmond was talking about, we had a big federal case where a group of young men were charged with crimes because they said they're called the Taliban. They said the Taliban's a gang. Prosecutors kept saying Taliban's a gang. We had folks that were in the community said it's not a gang, it's a rap label. I'll show you where the studio is. And they unraveled the case based on the knowledge of that reality, that community, and challenging the misinterpretation of the prosecutor trying to read the tea leaves of social media.
So Raj, my question is also directed to you. So far you've framed your efforts as primarily reaching out to public defender organizations, and I was wondering what role you view the private defense bar as playing. I mean, obviously there's challenges with how do you connect with them, but I'd be interested in your thoughts there. I'm also curious if you've met any pushback or response from victim services organizations. So you can imagine some groups viewing your efforts as helping people avoid the rightful consequences of their criminal acts. And I just wonder if that's come up, and if so, tell us a little bit more about that aspect.
Sure, yeah. On the first part of the question, we reach out to public defenders simply because it's a numbers game. People who are walking through our doors and the doors of partner organizations that we work with, which are churches, reentry centers, community centers, they're indigent. So almost everyone that we work with is getting either public defender or court-appointed attorney. So for us, that's why we work with them. But we work with private attorneys and we work with them in the same capacity that we would otherwise. Our concern sometimes is distinguishing, and maybe we do need an app that could allow people to kind of talk about their experience. We have some great private attorneys that we work with. We also know a set of private attorneys that essentially are taking the last penny of a family, knowing that they're not going to take the case to trial, and then they end up at the public defender's office anyways after the case gets done. And so some of the cumulative knowledge of experiences with attorneys gets shared at the meetings. That is helpful, actually. In terms of pushback, we haven't gotten it in any sort of direct way. In some ways, I think it's a really common sense thing if you tell the general public, well, yeah, there's victim advocacy groups, they show up at court. What about the other side? Oh, maybe there should be. We get some general pushback by anyone that is connected to anybody who is facing a criminal charge. The good thing for us is that's now a growing number of people, so it's no longer a siloed part of the community. It's so many people that have somehow been touched by the criminal justice system. It seems in some ways more mainstream.
I was just wondering if confidentiality is a problem. Maybe someone might need help but not want to talk in public or have their family discuss the charges against them.
And Meredith, right? Margaret, right. Margaret's a ringer because she's with the Participatory Defense of Montgomery County. But glad you brought it up. So for confidentiality, so at the meetings, we're very mindful of saying we're not lawyers. There's generally, in Montgomery County, I think there actually is a lawyer, public defender that's in the room, but some other counties there's not. And we just say that there is an attorney-client privilege that exists in the space, so be mindful what you're talking about. And we narrow the scope to what the discussion is where are you procedurally in the case, so that we're not discussing intimate details that could potentially be harmful not just for the person, but also anyone else who, we don't want anyone to be called as a witness. And so we've sort of baked into some protective measures so we don't end up crossing those lines.
Thanks for a really thoughtful panel. This question is mostly also for Raj. Raj, I'm a huge fan of your work, but I was curious, the work you're doing, which should be done in many more places, but it's very much within the criminal justice system, which obviously is the reality. I was curious to get your take, or if you've done any work or thinking on restorative justice models or community centered courts, or processes that would take some cases, maybe not the most serious cases, but sometimes out of the current criminal process that we know. And so what you're doing is clearly making that system, I think, much better. But do you think a different system would be even more effective, and you may not have the resources, but is that something you are interested in or thinking about expanding into?
Yes, we think it'd be good. And, any way that we could get people off of the conveyor belt is what we're aiming for. And I'll give one example of something that we've been thinking through, so forgive me if it's not fully cooked of an idea. But we were talking about bail and release a lot today. And risk assessment tools, and how does a judge decide? And a judge often wants sort of cover to offset the sense of responsibility. If I let this person out on OR or something, it's on me, right? And that's what they talked about this morning. We proposed something in our county that we're going to try to flesh out about a community release project, which is not making it about more supervision by probation and not making it just about incarceration, but is there a third alternative? And so that alternative would be when someone gets arrested and they're facing court, having community stakeholders in the room that could say, I'm going to work with that person to make sure that they get to court at their next appearance. I'll call them, we'll give them a ride. And if there's other tangential issues that lead to problems that otherwise would have happened, like making sure people get housing or employment, etc., that is this community stakeholder that already has a know on how to do these things. They play that role rather than probation, and rather than having some consequence if they sort of fail. It's going to be an experiment. We're trying to get buy-in right now. The advantage for us is it's already a thought-out idea. It's just being used on the reentry side. And so county officials, prosecutors, judges believe in that community connectivity on reducing recidivism on the reentry side. All we're saying is if you believe in it, use it on the front end so people don't go in the first place.
I thought the app for stop and frisk was fascinating. The chart that showed the sharp drop-off after its development. I wondered if any of the panel members have thought about whether technology might be used in any similar way for other actors in the criminal justice system. And so this app, in some sense, provides a degree of accountability to police officers by documenting their activities by members of the public. We have other aspects of the criminal justice system that are open to the public, in that people can go and watch trials, and they can observe prosecutors and their behavior in the court, they could observe judges in the court. Are there any apps that anybody's aware of, or any other way that might bring some degree of social media accountability in some fashion, similar to the Stop and Frisk app for other actors in the system?
So I can jump in here. When I was looking around at potential panelists for this, I came across a police officer in Washington, D.C. who promoted the use of a social media kind of, I can't remember, like a text group app, so that shop owners in Georgetown could share information with each other about potential shoplifters. Like, oh, I saw this person, they seemed very suspicious, they were this and this, and they look like this. And the shop, for this app was used for a while, and this is slightly different from what you're talking about, but this app was used for a while, and I think people liked it, the officer liked it, the shopkeepers liked it, and then somebody took a look at all of the different postings that were made, and they were almost all African Americans. And there was a bunch of fuss, a bunch of uproar, and they eventually discontinued the use of this app, which I find a fascinating use of trying to use kind of this like a crowdsourcing method to reduce crime, whether it increases the amount of racial bias that's in the system or it just makes it transparent. I'm not certain. That's one example.
I mean, I'm thinking in the university context, there are these websites where people can rate their professors, for example. I don't know how reliable those things are. I'm sure for mine, if they're all good, I'd say they're really reliable. It seems to me, worth thinking about, even if there aren't apps, what would be some of the challenges associated with it? Why does it seem to work for this one intervention, stop and frisk, so well? Is it because it's just a clearly defined moment that's observable, and other evaluation methods might be more contestable or qualitative? But one could imagine at least some way of crowdsourcing some degree of evaluation, perhaps, of experiences that either defendants have or others who can observe public parts of the process have, and in that way bring more sunlight to bear on more than just the police, because it's the criminal justice system is broader than just the police, right?
Agreed.
Yeah, another question about potential expansions of these technological applications, slightly different. Raj, it sounds like you haven't been using a lot of technology. I'm wondering what the possibilities are for merging the technology that Jason's developed and your community organizing. It does sound like you've developed a certain amount of systematization, and there are things that you do in many cases. You said something about sociobiographical slideshows. Could there be an app for families and communities of detained people facing charges, that has a Know Your Rights section, that has a Know the Criminal Process section, that has steps of engagement, things to do to help with gathering evidence and investigation and providing biographical material? What are the prospects and what are the challenges for some sort of technological application like that?
Well, the challenge was I hadn't met Jason before. Check that off the list. And to me the answer is yes. And that's actually how I met Megan. They were talking about, can we do this? And I think it'd be great. I mean, we're working with families in Birmingham that maybe don't have smartphones yet, but we're working everywhere, and this is a new line of communication. While Jason's talking, I'm going to pull up something very quickly, which I think could convert. I won't ask him to commit publicly to converting to an app, but yeah.
No, I have a lot of ideas since. I think that makes sense in terms of collecting the information as well. But yeah, we should brainstorm on that.
Yeah, this may be a step in that direction, right? So this is actually, you probably can't read it, but this is a project that we just started called The First 24. And it's for families, and it was born out of, you guys get, I'm sure the attorneys, you get a loved one, a friend, that calls you at midnight and says, so-and-so just got arrested, what do I do? And you may know the first immediate things you should do, which is, here's how you find out if they're in the system yet. Here's the number you call at the jail if they're not in the system. Here's the information you should have ready if there's going to be a pre-trial officer talking to them or calling you. Here's how you memorialize information that you think may be helpful for the defense attorney. And here's how you find out the first court date and where to go. And then we realized we should just put this down on paper and it could happen in any country, any county in the country. So the one on the right was our first one, that's our county, Santa Clara. And then we just put it out there with friends, and so the middle one's Nashville, the one on the left is Denver. And it's 6 basic pieces of information that most people won't have until it's too late. So that to me could be an app, like on the way to the bigger app, like, you know, could probably be done during the break for Jason.
So I want to squeeze in 30 more seconds to give a plug for a project I'm working on with the Defender Association here in Philadelphia. We've been talking about, it started off as an app, but now it's evolved into an automated text messaging conversation with sort of multiple kind of conversation branches. And the idea is similar in spirit in some ways to what Raj was talking about, ways of increasing communication with defendants and their loved ones in the period right after arrest, both in terms of walking them through the process of collecting any sorts of evidence that might deteriorate quickly, like messes that might get cleaned up, and injuries that heal, surveillance video that might get recorded over, as well as putting them in touch with their lawyer, reminding them of court dates, and giving them useful pieces of information that they might not know otherwise. So if you want to know more about that, talk with Mark Holden or I after. Thank you guys. This is great.